we go into now a discussion. I've got a couple of questions already listed, and if everyone's okay with it, I will just go through those first and then open up from the floor. But the first one is actually to Nathan, which is, how strictly are you restricted to looking solely at the legislation? To what extent can you go beyond that legislation? I think it's a question of, isn't it, to what extent is policy reform able to be a part of the, I suppose, parameters of the work that the Law Commission is doing? So perhaps if you could explain a little bit about that, Nathan, that would be a great help.
Sure. So we are the Law Commission, and we can only recommend reform to the law. So that's the bottom line on that. And which law we can recommend reform to will be determined by our terms of reference. So for example, we're looking at the 2014 Act. We're not looking at Credit Unions Act. And there are probably other acts which, well, there are other acts which interact with the 2014 Act, but we're not looking at those either. But what we can do is record in our publications other issues that are important to the cooperative community if we think they merit being put on the record. And that can include, so we have, talking to stakeholders already, we have heard various complaints about policy choices. Now, we can't change policy because policy is for government, and we're not government. But we can record concerns so that when government reads our report, they've got an indication of what the community is talking about. So if there is anything, one of the questions in our consultation paper at the end is there anything else? So you can use that to raise any particular issues. Obviously, we're looking to, we can't have a chapter in our final report that has 300 different policy gripes from 300 different people. But so far, we have been hearing policy gripes that sort of cluster around a common theme. And we can highlight that common theme and give examples of what it is. And we think that adds value to our reform process because it informs government of areas that they might want to look at.
Nathan, thank you for that. If I move on to Adrian's question for Adrian, well, two questions. I'll put them into one. It's basically, in hindsight, what would you have done differently in establishing your co-op, and what more could be done to encourage more NGOs to convert to a democratic structure? Are you okay with that, Adrian? Adrian there?
Is Adrian muted?
Is Adrian still with us? Or
okay, you hear me now? Hello,
Adrian?
Hello, can you hear me?
Yes, we can hear you, Adrian. Yes, get away.
Yeah.
You heard the two questions, did you?
Yes, I did. Yeah. So yeah, I don't think there's that much that I would have done differently looking back. I think we had to start somewhere, and the assistance we had from Anthony Collins was great, and it created a platform. But interestingly enough, some 5 years down the line now, Club Trevi is reviewing its articles again in partnership with Anthony Collins, and it's a chance for an engaged membership to shape the sort of cooperative that we are, whereas it was a bit top down previously. In terms of what could encourage other NGOs to become cooperatives, I think for me it is in that ballpark of procurement and the way that local authority care commissioners shape behaviours, shape organisation types and stuff. That's where I think you'd get other charities and social enterprises thinking, oh wow, they are really looking for democratic accountability. We haven't got any. Something like that would be an incentive to become a cooperative.
Okay, thanks for that, Adrian. Can I go back to Nathan then now for another question to Nathan? And it's the issue around protection against demutualisation. Do you think that is one of the issues that will be being considered within the consultation that's good, that will be underway?
Yeah, so I think that a couple of there isn't a chapter headed demutualisation, but I think demutualisation is relevant to some topics that we are considering in our consultation paper, in particular asset locks and the potential to entrench society rules, entrench them at a level higher than is set by the statute. So, for example, it could, in theory, if that was one of the reforms, it could, in theory, be possible to say that you cannot demutualize unless you have unanimity of votes. So, I think those are two ways, and we are looking at voting structure. So, one of our speakers spoke today about one person, one vote. That's a debate that is in the consultation paper as well.
Thank you, Nathan. I've got another one for you, actually. It says, question for Nathan stroke Cliff. Well, Trevi could have transferred to a charitable CBS, but it would then not have a charity number. So many funders don't really recognise it as a charity. Could a charitable CBS get a charity number in future?
Yeah, well, they don't get a charity number because they cannot register with the Charity Commission because they are exempt charities. And that is something that we are looking at in our consultation paper, whether their position should be regularized, as it were, whether they should be able to register with the Charity Commission and therefore get a charity number, and then also who their regulator is going to be. Is it going to be the Charity Commission? Is it going to be the FCA? What arrangement between them might be necessary? So yeah, that's quite to the fore in the consultation paper.
Thank you for that. And I'm going to go open to the floor. I think I've taken the ones from the chat. Firstly, over to Ian Hewitt.
Okay, I think my question's mostly directed towards Nathan. And it's a point that I raised with Ian Snaith on one of the consultations, that I was involved in establishing a community co-op here in Nottingham locally. And then that community co-op got into trouble and a whole group of people got involved in it to try and save it. But they weren't aware that it was a co-op. So they orchestrated an election of the executive and wouldn't allow anybody to vote other than those people that were on the executive. They didn't have a register of members and stuff. And so it was a very bizarre position. I ended up making myself very unpopular by saying, you really should have some democracy here. But I think what would have helped, because it was an ICOM community co-op, and nowhere in the Constitution did it say it was a cooperative. So I think a demand that any constitution says that this organisation is a cooperative would have helped that one. And and you talked about, should there be a formal definition of co-ops? I think there probably should be, but Ian Snaith was very sceptical about that, whether it was useful. But I think there's been a generational change. So I think now people haven't got much of an idea of what democratic organisations are. Now I've got very little idea of what cooperatives are, given that the state of the cooperative group. So we're in a position where you've got to be of a certain age, and I still feel young in the co-op movement, which, but
as we all do.
Yeah, of course, it's energizing, but I think we've got to recognise that younger people haven't really got a clue, because most of the democratic process has gone in universities, virtually everywhere. So I think that the corollary is that we really need education. So there needs to be a process that re-energizes and embeds this notion of cooperation.
Do you want to respond to that, Nathan?
Sure. So a definition of a cooperative, if we can come up with one, we think could be a very beneficial thing to have, because it provides, it has explanatory power. If you can say this is what a cooperative is in just a couple of sentences, as a minimum, that sets that provides a ground level for a conversation, for a debate. It communicates strongly so people understand. They get an immediate sense of reference. So you can tell other people what you are, funding bodies, tax authorities, whatever it might be. It provides a hook as well that other policy makers can hang their new policies off if they understand what it is they're dealing with. But what we're trying to, the challenge is, can we come up with a definition? Because what you want in a statute is something that is minimalist. These are the minimum requirements you need to meet in order to be registered as a cooperative. How far beyond that you go, that's aspirational, and that's for each cooperative to decide how far down the path it wants to go. But can we come up with something that is minimalist, that we can all agree on? And that's quite challenging, because when you look at the current definitions that are out there, I mean, if you look at the cooperative principles, for example, they have words that, let's be generous, they are open textured. They can mean different things to different people. And you know, each one of the cooperative principles, it comes with a paragraph of explanation and then 100 pages of notes in a separate document. Democracy is one of those words that's in there. Democracy can mean different things to different people, and lots of different and in terms of taking votes, lots of business associations other than cooperatives take votes on things, but they all take votes in different ways. So this is one of the things that we do flag right at the beginning of our consultation paper. Can we come up with a definition? And in particular, what do we do about the notion of democracy? Now we've come up with some provisional proposals. Well, so far I've come up with some provisional proposals. Whether it meets law commissioners' satisfaction, I will find out in a couple of weeks. But the idea of those provisional proposals is to focus the debate and to focus responses. Because if we just ask the question, what definition would you come up with? We will have 100 different responses and we'll get no further forward. So I've come up with some provisional ideas, but they are provisional. The whole purpose is there is so that people have to engage specifically with the detail, and that will help us to move forward.
Thank you. Thank you. Cliff, your hand is up.
Yeah, I wonder, Mick, I'm speaking later, so I just wondered if I could make a point here, which I will be coming on to address. But I'm one of those in favour of pursuing a definition, and Nathan's highlighted all the challenges of coming up with something. And one of the things to do, of course, is to find out what other jurisdictions do. And so we are engaging with our learned colleagues outside this country who are cooperative lawyers who have experience of this area. But the salient point is this, that we know what a charity is because it's defined, and government knows what charities are. And if government wants to encourage charities or give them particular benefits or to be treated in a particular way, it knows it's what it's dealing with is ring-fenced. And I think Adrian's put his finger on it, where he says it's the relationship between charities and co-ops and companies. Without a definition, that those boundaries are blurred, and that makes it difficult for practitioners who are setting something up, helping people to set something up, and it makes it difficult for government who want to encourage and support particular aspects of the economy, particular types of business. They need something to latch onto, as Nathan has just explained. So yeah, I suppose that's an encouragement to stay to the end of today's sessions because I'm on last. So that's all.
Okay, well, listen, that's a helpful contribution that fits in well with what's just been discussed. Richard, you got your hand up.
Yeah, I just wanted to say something about the asset lock question. I think I'm broadly in favour of having some kind of embedded asset lock. Although I do recall when I was on the Co-ops UK board 20 years ago, Ben Reid saying that he felt had the Co-ops Act that was drafted in 98, 99 and never actually reached the statute book been enacted, he felt that the way that an asset lock in that draft had been put in would have been very damaging to trading co-ops, in the same way that some of the restrictions in the Building Societies Act probably invited demutualisations rather than discouraging them. But I think the thing that I wanted to say was 2 points really. One is I think we should be a little bit cautious about the extent to which asset locks protect assets, because I think if you have members and a board who are determined to demutualise, you can have as many clever constitutional fixes as you like. People will find clever ways to get assets out of the asset locked institution, I suspect. I think the real protection for assets is having a lively democracy and engaged members and a co-op which delivers services and benefits that its members really appreciate. But the other point is about the recognition that co-ops have in wider society. I've recently had an example of working on a community buyout of a hardware and gardening shop in Kings Heath in Birmingham. And we copied something that the Wales Co-op Centre has supported a year previously down in Pembrokeshire. We wanted to do it as a co-op. We ended up doing it as a community benefit society because we wanted to access, well, because we were buying expensive freehold property, we needed funding from the government's community ownership fund. And you could only apply for that funding if you had a legal structure that included an asset lock. Had we been a community interest company, despite the fact that CICs are allowed to distribute, I think, a third of their profits to the providers of capital, so, you know, a lot less community benefiting, if you like, than a co-op structure. Because CICs have a form of asset lock, albeit I suspect quite a weak one, they have the recognition within government and within policy circles that they are a kind of community benefit structure. We could have done it as a co-op. As it happened, we wanted withdrawable share capital and democracy and all the things that are easy in a society structure. So we went for a CBS. But I think it's a similar thing. I mean, I know Ian and I have had debates about renewable energy co-ops and, you know, is it genuinely a co-op and can the members genuinely benefit and can they buy the energy and all that kind of stuff. But I think there's also something in the energy co-op world about, is it asset locked or not? So I just wondered if any of the panelists had anything to say about those issues.
I'll go over now. We've got a few minutes left before we close this session. I don't know if Nathan wanted to lead on in response to that, but just one further question there from Chris Hall, which says, to what extent do numbers percentage impact upon creating or blocking, inhibiting cooperatives? It's a parallel with trade union recognition agreements and taking industrial action, etc., only if a percentage of members have voted accordingly. I don't know if you had any comments, but then I'll ask if anyone else wants, the other contributors want to come in on this. Nathan, did you have any general comments on the last contribution and the question there?
Yeah, so for the on the asset lock question, I agree that ultimately, if you want to avoid demutualization, you have to keep your members happy. You've got to be delivering something, and you know, if every member is just sick and tired of the whole thing, they're going to find a way of shutting it down and dissolving it. And that's true of any business association, however well-meaning it was when it was set up. Otherwise, I wonder to what extent there's been so much talk about asset locks, and I wonder to what extent actually it's that useful, because asset locks tend to be a bit of a blunt tool. Well, no, blunt's not quite right. A bit of a sledgehammer, or they're a sort of attempt to be a one-size-fits-all, but they're this massive thing that kind of goes on everything. I wonder if rule entrenchment might be the better way to go on some of these things, because with rule entrenchment, you can pick one very specific idea and say, this will only happen if this many people vote in favor of it. So you could put demutualization in there without necessarily hamstringing all your assets for the rest of your life. So I wonder if once we've introduced rule entrenchment, that might be a more targeted way of setting higher thresholds in some things. And maybe that comes on to this other point, what was this other question that was asked? I'm not sure if I'm going to get this quite right, but this was how I read the question, which was, you can set up a co-op with 3 people. After that, what voting thresholds you need to achieve in order for the cooperative to do anything is up to the rules of the society. So the rules of the society can set different voting thresholds for different behaviors, except that with some actions, the statute currently sets what threshold you need. And those are on the big questions like demutualisation or conversion or amalgamation or transfer of engagements. And one of the things we're suggesting with rule entrenchment is that you should be able to exceed those limits in your society rule if you want to. So at the moment, the statute tends to say you need a 75% vote threshold to transfer engagements. And we would say, yes, that is the minimum. But if you want, maybe you should be able to entrench that and say you need 80% or 100% of 50% voting or whatever it might be, but to go a higher level if you want to.
Thank you, Nathan. James, you've got 1.5 minutes.
Okay, thank you. Yeah, just very quick. I'm not actually on this panel, but I thought I'd just jump in. So I had a really interesting conversation with a couple of people at the Treasury the other day. So some of you might know that last year the Treasury supported a private member's bill to give himself the powers to introduce. I suppose the shorthand reviews is asset lock, but I know Cliff doesn't like it because it's kind of misleading. It's essentially to introduce the ability for a cooperative society to have essentially non-disputable capital surplus, so the capital surplus residual at the end of the life of a cooperative, and to say that some or all of that capital could be Commonwealth and can't be distributed amongst members. I suppose a very, very minimal form of asset lock. And there's always been a question about when will the Treasury actually do anything with that power to introduce the legislation, and they did tell us this week that they now would plan to use that power after the Law Commission review has made its recommendations. So they would like to understand how the rest of the law is supposed to change before it brings in that particular element. But they still do plan to do it, and they recognise the importance of it, but they would like to see it within the broader context of legislative change. So I just
no, it's really helpful. A final point on that. Thank you for that. Look, can I thank all the contributors this session? We now have a 5-minute comfort break. When I was younger, we used to call them toilet breaks, but now they're called comfort breaks, aren't they? And we then move on to session 2. My apologies, I have to leave to go into another meeting now. Thank you to all the contributors and participants, and I look forward to hearing some feedback from the second bit, which unfortunately I'm going to be missing. Thank you, everyone.